Article 23(4)(b) of the Constitution states that a person arrested or detained upon reasonable suspicion of his or her having committed or being about to commit a criminal offence shall, if not earlier released, be brought to court as soon as possible, but in any case not later than 48 hours from the time of arrest. Human rights defenders look at this article as the cornerstone of justice, and its existence in the Constitution means that when a suspect is arrested, police and DPP's office must work around the clock for that suspect to appear in court. But the DPP, Justice Frances Abodo, says it's not possible with some cases, which is why her office is pushing for an amendment in the Constitution.
For purposes of us having some of these cases which are so complex, so that by the time because at the end of the day we really also don't want people released because that would be anarchy for the country.
Justice Abodo made it clear that her office is not pushing to remove the 48-hour detention provision in the Constitution, but a window for the prosecutor to ask court for an extended police detention of a suspected terrorist or big money thief beyond 48 hours until investigations are complete.
Every case will be taken and we shall appear in court, inter-party. There will be also counsel for the defense. And if we convince the judicial officer that actually we need enlargement of time, they will give it to us. But if it is also refused, that's really... but we're just saying the practical bit is that now we are dealing with crime, which has changed in terms of how it is committed and the people who commit these crimes.
However, Justice and Constitutional Affairs Minister Norbert Mao, whose ministry's role is to sanction law reforms, admitted that he's divided on the matter but promised to do something.
The Minister of Justice in me wants to amend the law, but the human rights activist in me does not want to amend the law. The debate is still going on, but I do believe that we are going to come up with some proviso.
Mao and the DPP agreed on inefficiency in the office of the DPP to investigate cases in time, and Mao implicitly stated that charging suspects with capital offences like terrorism is many times a state tactic to keep them on remand.
If we don't have the capacity to gather enough evidence, that is why in Uganda today, most of the time, if your case is not yet well investigated, then you are charged with some outrageous crime like terrorism. So that way you are just taken to court and immediately taken to jail. You may not actually have anything to do with any terrorist activity. But you know, terrorism is such a broad crime that it is a catch-all.
These are the 10th annual conference of East African Association of Prosecutors in Munyonyo, Kampala. The Chief Justice, Alfonso Winyidolo, hailed the cooperation in dealing with cross-border crime.
It is an opportunity for us to share experiences, to gain from best practices from elsewhere, that is other jurisdictions, to enable us craft solutions, especially for the betterment of our criminal justice system.
The 4-day conference is putting emphasis on dealing with crimes that affect women and children. The delegates will on Tuesday come up with resolutions to equip prosecutors on how to deal with transboundary crime. EDWARD MUHUMUZA,